Reserve. The root of all our evil, it begins with the Federal Reserve. Hey, yeah, well, let's go back in time when everybody was so proud of America.
I'm Tommy Salmons. This is year 0. Today, I get gangbanged by attorneys. Michael Harris and Patrick MacFarlane join me. We talk Ketanji Jackson Brown, or Ketanji Brown Jackson, whichever way that new Supreme Court nominee's name is said or spelled or whatever. We talk criminal law. They tell some war stories. We talk a little bit about ESG, vaccine passports, and, just some things that are on our minds that concern us about the world going forward. So I thought it was a great conversation, and it was good to get the perspective of two defense attorneys and how they see the criminal justice system and the court system and all that good jazz. So I think y'all will really enjoy this. I enjoyed it myself, as I probably already said, but I haven't finished my coffee yet, so bear with me as I repeat myself over and over and over and over. RyanBunting.com. For all of your graphic design needs, go to RyanBunting.com. I say Ryan Bunting over and over and over and over because RyanBunting.com is the most racist graphic designer out there. And for all your racist graphic design needs, go to RyanBunting.com. If you're a true racist, RyanBunting.com is the website for you. LibertarianInstitute.org. That's where you'll find this podcast. Patrick MacFarlane, who you'll hear on this show, and his Liberty Weekly podcast. Keith Knight with Don't Tread on Anyone. Kyle Anzalone with Conflicts of Interest. I think he also has Will Porter and Connor Freeman joining him on his show as co-hosts. And they are very knowledgeable. We'll be getting Connor Freeman on here pretty soon. I promise. I have reached out. We are talking about a subject. So we'll look forward to that, right? Right. So libertarianinstitute.org. And that's where you'll find Sheldon Richman writing and Scott Horton's show and all that good jazz. So go to libertarianinstitute.org and keep up with all of the libertarian thought leaders at the libertarianinstitute.org. It's kind of like a blue-collar version of Mises Institute. Yeah, that's the best way to describe it. Anyway, thank you, Tom Burton, for the music. Enjoy the show. All right. I'm here with Mr. Michael Harris. How are you doing, sir?
Doing well, Tommy.
And my brother over at the Libertarian Institute, Patrick MacFarlane. What's up, man?
Hey, Tommy. Glad to be here again.
Yeah. Well, this is going to be fun. I've never been gangbanged by attorneys, so let's see how this goes.
That sounds like the seventh circle of hell.
I can only go down from here.
Well, I'm just going to say you should have known my ex-girlfriend and let it go at that, okay?
We have a new Supreme Court nominee up, and actually this has kind of turned into a theme for me and Michael. We tend to record an episode every time new Supreme Court justices come up. You know, I think we did one for Kavanaugh and Gorsuch and Amy Coney Barrett last year or the year before, whatever that was. You know, COVID, all of it's running together for me. So we got Ketanji Brown Jackson. Now, I keep track. One of my habits is trying to keep track of what the left media and the right media are talking about, because I want to kind of have a view of where they're coming from, so I kind of know how to talk to these people. And it seems like the left media has a problem with her adherence to corporate structures, and that she has a tendency to rule on the side of businesses. But the right media has a problem with her activism, and that she was involved in an organization called Demand Justice, which organized the Handmaid's Tale protest around the Kavanaugh hearing. But that's pretty much all I know about this woman. I know that her last two rulings have been contested, and for reasons I'm not familiar with. So who is Ketanji Brown Jackson, Michael?
Well, she is Joe Biden's nominee to replace Justice Stephen Breyer. And she is African American. And I don't particularly like the fact that Joe Biden just come out and said that he definitely would appoint an African American female as the next Supreme Court justice. But I will say that I think she's qualified for the position. She grew up in Miami. Her father was a lawyer. Her mother was a school teacher. She went to Harvard. Some people say that she got into Harvard and Harvard Law School by affirmative action. I don't know if she did or didn't, but she did graduate near the top of her class in Harvard. She was on law review in Harvard, and she did get was a clerk for justices, and ironically, she was a clerk for Justice Stephen Breyer, of all people. So it's kind of like she's replacing her former boss. She went to the she got nominated to was a federal district court judge for a while, did several jury trials. Very recently got put on the Second Circuit Court of Appeals, which is mostly in the District of Columbia. Now, the one thing I think that gives me personally some hope that maybe she'll make a difference is that she actually did work for the Federal Public Defender's Office for a while. And my understanding is that she actually did go down to Guantanamo, and she did actually talk to some of the detainees in her capacity as a federal public defender. For the most part, I don't think she's going to make anything radically different rulings than her former boss, Stephen Breyer, did. The one area that I am hopeful that she may make some different rulings is when it comes to the rights of the accused when they're accused of crimes, because she was a federal public defender. And so now the official shortlist that came out, I think one thing that is noteworthy is that the other African-American female that was listed was a South Carolina judge named Childs, who was really promoted. Talk about your unholy alliances. Promoted by Lindsey Graham and like one of the leaders of the civil rights movement, who just, for all practical purposes, got Joe Biden the primary in South Carolina. But they were really pushing for this woman named Childs. But apparently somebody did some digging, and one of her rulings, she really hammered somebody on a drug case, and that came back to bite her. So I kind of find it funny now that all of a sudden that's something that's held against judges is coming down hard on drug offenders. And that's a positive sign after all these years, So, excuse me. Like I said, I don't think she's going to be radically different than Breyer for the most part. But I think us libertarians just need to be honest that Joe Biden is not going to nominate Judge Napolitano to the Supreme Court. And even if Joe Biden did nominate Judge Napolitano, there's no way the current Senate would ever confirm him anyway. So I just think we need to kind of like let's give Ketanji Brown Jackson a chance, see what she does. I'm cautiously hopeful that maybe she'll make some better rulings on criminal cases.
Okay. Patrick, you have any thoughts about anything that Michael said?
Yeah, I would hate to be in her position, because I think the specter of being accused of being a diversity hire will probably haunt her for the rest of her career. I would hate to be nominated by Joe Biden, who explicitly said that he wants to nominate an African-American female. That being said, I guess my biggest concern with her kind of revolves around her position on the Chevron case, which is a landmark Supreme Court case that dealt with deferring to administrative agencies in their policy decisions. And the reason why, and I think you'll agree with this, Michael, is as we've seen these mask cases and the COVID-19 litigation cases go forward, what we're really seeing is it's government by emergency, and the infrastructure has been put in place, I think, during the 90s and 2000s to give huge powers to administrative health agencies when a public emergency is declared. And this allows the governors, there was some model legislation that was passed in the states, which allows the governors to declare a health emergency and to name the leading administrative agency that is to basically take, I think, like medical martial law powers. And it gives huge powers to these agencies to declare the emergency powers, do things like quarantine people, surveil people, and track people. And admittedly, she's not terrible on this, but she doesn't seem to challenge the wisdom of the Chevron case. And I think that going forward in the next 10, 20, 30, 40 years, we're going to see what we saw with COVID-19, is that these administrative agencies are handed this huge, gigantic power over the lives of Americans when an emergency is declared. And if you go through all these mass cases that have been litigated, I've read a few, and what they always end up falling back on is giving basically what is a de facto rebuttable presumption that the CDC is correct. So whenever anyone wants to challenge these mask and vaccine orders, you're already starting behind, because the courts just take the CDC data for granted and all of these studies for granted. And it's really the burden of proof, in effect, is on you to disprove their studies.
I do think we ought to let the listeners who are not lawyers know that when Patrick's talking about the Chevron, that comes from a very, very famous case in the late 80s. It was the oil company Chevron versus the Environmental Protection Agency, which went to the Supreme Court. And the Supreme Court at that time, for all practical purposes, ruled that bureaucracies could define their own terms and they could interpret regulations any way they wanted to, and that the courts would defer to their interpretations. And we call that the Chevron doctrine. Now, that has led to a lot of abuses, and it has led to, for all practical purposes, now we're a country ruled by administrative agencies that officially it's Congress, United States Congress created them and delegated the authority to the president to administer them. But in reality, they have pretty much became a law unto themselves. They kind of remind me of the old Andy Griffith show where Barney Fife could like make up his own interpretations of what the penal code was. And so he'd come up with all these nutty interpretations. And then good old Andy had to like, oh, Barney, just got to let this people go now. Can't lock them up for this. Well, we don't have anybody now, hardly ever, except for apparently 3 Supreme Court justices that will occasionally tell these administrative agencies, like, no, you can't just make up your own rules and your own rule interpretations. I think it's kind of ironic that Neil Gorsuch has become the leader of that faction. They call it the major questions doctrine. We're saying that it should be Congress that addresses major questions, not these nameless, faceless bureaucrats that nobody ever elected. I say it's ironic because Neil Gorsuch's mother was the head of the Environmental Protection Agency when the Chevron case came down. So must have had some interesting family dinner conversations about that. But that's what kind of Patrick was talking about. And yes, I do not see Ketanji Brown Jackson voting to overturn the Chevron doctrine or limit the Chevron doctrine. Now, she did rules a few times against some Donald Trump administration agencies, so maybe there's some hope. I'm not going to hold my breath on it, but maybe there's some hope she will.
I wonder if that's because I worry. I guess I'll frame it this way. I worry that the way that she was chosen and her ties that she's going to be an activist, that she's not going to act as a judge, that she's going to act as an activist, and that these rulings against Trump's administration was because it was Trump's administration. I wouldn't be shocked, as long as Biden's in office, that she is chomping at the bit to find something to rule against the Biden administration on, just to prove that she's not the Democrats' token. But at the same time, I'm looking long term. How is she going to act? Is she going to be an activist, or is she going to be a judge? Which one comes first in her mind?
My guess is that she's 51 years old, which is actually fairly young for a Supreme Court justice. And as a man who used to work, my dad would say, I don't have psychedelic powers. But I'm sitting here thinking that she's probably going to be on the bench for about 30 years. And so she's probably going to want to keep a low profile for the first few years, probably till Biden. Because, I mean, let's be honest, Biden's not going to be president for very long. They may pull out the 25th Amendment on this cat, because he's having a hard time knowing what area code he's in.
The Iranians disagree.
So I think she's going to keep a low profile for the first few years. That's my prediction.
I have a pretty interesting take on activist judges, because, of course, it's kind of an aside. It's a little off topic, because we could really spiral down the theoretical, like, judicial philosophy route. But I was vice president of the Federalist Society in law school, and being a conservative jurist means that you say what the law is and not what it should be. I think my take on it, Michael, I'm not sure if you're familiar with some work that I've done, but my take is that the Supreme Court should not have the power of judicial review. And if they do, they should follow the clear case doctrine, which was set down. Tom Woods had, William J. Watkins Jr. had a piece on this about how in the state courts, the state Supreme Courts, it was an impeachable offense for the court to strike a law down unilaterally. And so you're caught between a rock and a hard place. As a good conservative jurist, you would like for judges to call balls and strikes, as it were. But then at the same time, isn't the common law built off of some sort of judicial activism? You know what I mean?
Well, yes, especially if you go back to Old English common law.
Yeah.
There was a lot of judicial review and a lot of it. But I think the main thing is when they're pushing the three justices that are pushing the major questions doctrine, which is, to me, I think it's pretty clear from my study of American history and constitutional law that the framers really intended the legislative body to be the one to handle the major questions, because they were the ones that were most responsive to the people. They were closer to the people.
Definitely.
And so they definitely did not want to create a new king, with the exception of Alexander Hamilton, which, if you want me to talk about that, I will. But, George Washington made it very clear. It's like, no, I do not want to be a king. Do not try to make me a king. I will not be a king. Where's George Washington today? I'd like to know. But, so that they really wanted the legislature to be the branch that addressed the major questions. And three of the justices, Gorsuch, Thomas, and Alito, have made it very clear. It's like the old saying, you can lead a horse to water, but you can't make it drink. Well, it's like these three justices, Congress is the horse, and they've hooked it up to a tractor, dragged it into the middle of the pond, and trying to get it out and force his head underwater to force it to drink. And it's just they just won't drink. I really feel like Congress has totally dropped the ball, and it's in the name of this red-blue culture war that we find ourselves in. They just simply won't do their jobs, what they're supposed to be doing.
I kind of want to pivot.
I'm kind of concerned about what it's going to lead to.
I want to pivot off of what you're. That's fine. I just want to pivot off of what y'all are talking about right now into this this culture war between the two parties that we're seeing. It seems to me like the reactionaries have reacted. That's kind of my take on this. So for decades, I've listened to conservatives talk about these activist Supreme Court judges, you know, legislating from the bench. And I mean, you have like blatant attempts at this, like when it comes to Roe v. Wade, like that should have been taken up legally. That should not have been taken up in the courts. That should have been taken up in Congress, whether it's in the states. Actually, I think it should have been the states, but whether it's in the states or federally, that did not belong in the courts, and the decision being made and a precedent being set by the courts for this to be law. And so conservatives have gotten very fed up with we'll give an inch, but we're not going to fight for anything. And I listen to these guys and I can hear them, and what they want is returned activism. They want their justices. They want Kavanaugh, Amy Coney Barrett, you know, Gorsuch. They want these guys to act in retaliation against the progressive movement, right? And they haven't done that, and probably rightfully so. They're probably correct in not acting that way. But what the conservatives are looking for right now when it comes to these justices that they're putting in place is they're looking for their own activism. So now you're going to have this, you have this tit for tat, right? So how does this go forward? I've often heard that Democrats are the majority of the American population are Democrats. But from my experiences with people, they're not Democrats. They may call themselves Democrats, but whenever I talk to people, they're not at least what today's Democrats are.
Yes, I do think that I call them the tribes, or you can call them the parties, but it's kind of like the red tribe wants red activist judges, the blue tribe wants blue activist judges. And to me, the problem is kind of like, no, we shouldn't have activist judges, period, for the most part. Right. Now, you brought up Roe versus Wade, a little bit of a tangent, but it's short and sweet, and it's to a point here. Most people don't know this, but Hugo Black, justice that wrote the opinion Roe versus Wade, he worked for the Mayo Clinic. He represented doctors, all right? He didn't give a damn about women. He cared about doctors. So he pushed Roe versus Wade opinion to protect doctors, not to protect women. All right. Mm-hmm. So, yeah, he had an agenda. And I agree with you. To me, it's a question that should be handled by state legislatures and left at state legislatures. Now, the blue tribe will argue, well, that means that, rich people can go to a different state and have abortions, which valid point, whatever. But to me,
like Bernie Sanders said, just write a book. You can be rich. Yeah.
Well, we're sitting here arguing about Roe versus Wade, which is almost as old as I am. I mean, It's kind of like, to me, it resolved absolutely nothing. I mean, 50 years now we've been talking about Roe versus Wade. Half the country loves it, half the country hates it. It resolved absolutely nothing. We need to find a different solution, go in a different direction. Hey, Patrick, what do you think about that?
Well, I mean, I agree. I agree with that. It should be left to the states. It kind of harkens to this thing that I made this term. I call it bastard jurisprudence, which is like when there's a piece of common law or a piece of positive law, a piece of legislation, and then where the courts, in their role of judicial review, they try to determine what that piece of positive law means. So there's a statute that's passed, and the judges, the courts grapple with the meaning of this statute. And in my opinion, the 14th Amendment, the Constitution itself, is a piece of positive law. It's a piece of law that's created by a legislature. So essentially what all constitutional jurisprudence is this bastard jurisprudence where judges sit around trying to determine what this piece of positive law means, and they create their own jurisprudence based off of that. And so essentially, that's the long-winded way of saying that this is just all make-em-ups, that they just made up the entire thing. And I don't know. I think the entire thing stems from this power of judicial review that the court shouldn't have in the first place, that John Marshall took for himself in Marbury versus Madison.
Well, I'm an old Murray Rothbard student, as Tommy knows. So I kind of have to say, I think there's some natural law principles embedded in the Constitution.
I wouldn't disagree.
Yeah.
Yeah. I
don't
guess
know if you agree with Murray Rothbard or not. So,
well, what do you think about the 14th Amendment itself? Like, I agree. There are two sides to that coin for sure. But if they just come up with the 14th Amendment and then justices across the century scratch their head and say, oh, well, I think that establishes this intermediate scrutiny and strict scrutiny, and all these different levels of scrutiny. And then we're just going to make up, targeting and stuff like that.
Well, I would like to see more strict scrutiny reviews myself. I mean, to me, intermediate scrutiny is a joke. Okay, so for the non-lawyers listening, whenever the courts review a statute, there's three standards they can apply. The most common is they call it the rational basis test. Is it rationally related to what they consider a legitimate government function? I don't know. Does it help you tie your shoelaces? Yeah. Okay. So it passes the rational basis. Basically, the government always wins whenever the courts decide they're going to judge it by the rational basis standard. The other extreme is what they call strict scrutiny. It's kind of like it comes from a famous case, Korematsu, which hopefully we'll get to later, where the courts say the government has to say that there is a fundamental right that a citizen or a group of citizens have, and the government has an obligation to show that they have the narrowest possible tailored remedy for something that is absolutely essential. To the best of my knowledge, there's only been one time that the Supreme Court has ruled that, yes, the government did pass the strict scrutiny test, and that was the Korematsu case, which ironically is one of the worst ones in Supreme Court history. Now, in between, they have what they call intermediate scrutiny, which is kind of like, well, we don't entirely say it's going to falls under strict scrutiny, but we don't say it falls under the rational basis test either. So in reality, it's kind of like Barney Fife. He can just make it up. So the judges can just, once they decide that, oh, we're going to judge this by intermediate scrutiny, they can just make up whatever rules they want to. There's absolutely positively no consistency in any shape, form, or fashion. If the majority of the judges say that, yeah, it helps them tie their shoelaces, that's good enough. Boom, they win. Okay. So is that a fair summary, Patrick?
Yeah, I think it is. Yeah. I guess with the caveat that this is only when the court reviews a law against the Constitution. So under the 14th Amendment, because I didn't know this, Michael, when I started law school, and maybe this is a really bad thing, but a lot of people aren't aware that the original federal Constitution wasn't supposed to apply to the states. And it wasn't until the 14th Amendment was passed that the Supreme Court started taking it upon itself to one by one, in decision after decision, apply the 14th Amendment, apply the Bill of Rights to the states through the 14th Amendment, through the window of the 14th Amendment.
Dave Benner wrote, I don't know if you know Dave, but he's with the 10th Amendment Center. He wrote a book about this called The 14th Amendment and the Incorporation Doctrine.
Yes. Yeah.
It's very good. And it's very important. Easy read. I mean, I read it in an afternoon. Yeah. And I was like, wow, that's crazy. But yeah, there's some good work out there on that.
Well, like a lot of the things, the 14th Amendment rose after the Civil War, which the Civil War was really the event in American history. It's kind of like pretty much everything before it led up to it, and pretty much everything after came as a result of it. So, yeah, the 14th Amendment, and it's a lot of it came from the Dred Scott decision, where the Supreme Court for all practical purposes, said that people who descended from Africans had no rights. They couldn't be citizens. And so the 14th Amendment said that, no, if you're born in the United States, you're a citizen, which I think that should be revisited now at this stage of of our history. But, I don't think it will be. But, I think that the 14th Amendment has, as Patrick said, the original Bill of Rights did not apply to states. It was only to limit the federal government. The 14th Amendment did apply to the states. So I have made 14th Amendment arguments in courtrooms, sometimes successfully, not always, but I've made that argument.
You got to use the tools available to you at this time.
Yeah. I mean, you had sent over in your notes, Michael, that you'd even used race as an argument at times because that's a tool in the toolbox that may need to be used for specific circumstances.
Yeah, it's a thing of going into a courtroom. I want tools that I can use. Now, there's a lot of people in they call it the critical race theory, even though I think there are times where you have some legitimate points. I tell young lawyers that the race card can be a very valuable card to play, but it's a card that you better play very, very sparingly, and you better have the facts to back it up. My big complaint with the critical race theory, folks, is you ever heard the saying that when the only tool you have is a hammer, everything begins to look like a nail? Yeah. That's the critical race theory, folks. That's everything they see. Now, two examples that I can give from my practice. One of the first cases I had, I was appointed to represent a young African-American man. He and his brother were leaving a family gathering 2:00 in the morning in Mesquite, Texas, and he was stopped for, they accused him of driving while intoxicated. Absolutely nothing in the facts or on the video to show that his driving was any way out of the ordinary. To me, it just looked like a blatant case, and it helped that the arresting officer was, had only been on the force for like 6 months, white, redheaded guy. He looked like he could start an Jack Foxworthy video. So it's like, this is a case of driving while black. Okay, let's be honest, folks. That's the reason why they stopped him. He was driving while black. And the jury found him not guilty. Now, I had another case several years later, also a drunk driving case. I was representing a much older African-American man that he was in a car that went off the side of the road and tore up a woman's fence. He was swearing up and down that, no, he was not the driver of the car. He was the passenger of the car. And the woman told the police, no, he was the driver of the car. So the police didn't see him drive. And he was making the argument that that woman was making that story up because she was a racist. And I'm like, well, I don't know about that, sir, but it's your case. So we'll see. Well, the woman shows up on the day of trial with her husband. And I looked at my client and I told him, that hound ain't going to hunt, as we say in East Texas. All right. Like, her husband was darker than he was. It's like you better come up with a much better story real fast, buddy.
Yeah. Now they say that, like, if you marry somebody of a different race, you're racist, because then you're just trying to utilize your dominance over that race in your family life. I mean, you can't win with these people.
No, you can't. It's politics. It's a political performance art, and they have a political agenda that they're promoting, and I think it's going to do an awful lot of damage to our country. I think the main thing is the pandemic has really exposed a lot of it, because I don't have children myself. But my understanding is that a lot of parents, when they got locked down and schools went to virtual learning, suddenly a lot of parents were actually watching what their children were being taught. Mm-hmm. And it's like, we don't like this. This is not appropriate at all.
Right.
And I, from what I've heard, particularly in San Francisco, there has been a tremendous backlash towards the teaching of critical race theory. And like I said, I think there's points where you can point to and say there's legitimate criticisms that they have in our history, in our legal system. But my understanding is they're just basically running around saying all white males are evil. And it's like, no, you to me, you can't say that. And I
you
think
can't say it
been a lot
about
of
any other
backlash.
race. Yeah, you can't say it about any other race. It's like, so my comeback to
Well, I
something
can
like
point out-
that, when somebody tells me that, you know, I'm suffering from white privilege or all white males are evil, I just tell them I've never identified as white. I like being interesting. So, yeah.
So I just had to pull out my defense manual because I had to double check this, but it can also come back and bite you in the ass too with this, the idea that everything has to be based on race targeting, because there's a defense under under the Constitution called selective prosecution. And I don't know, Michael, if you've ever had to use this, but it says that according to my manual, this defense is based on the Equal Protection Clause of the U.S. Constitution. It is a pretrial defense. Selective prosecution is available as a defense when a prosecutor selects one person to prosecute, but does not prosecute other persons who may have committed the same crime. An example of selective prosecution is the prosecution of prostitutes, but not of their customers. And so my understanding is that you have to show that it's racially motivated. Is that yours?
Well, the one time I did use selective prosecution, ironically, it was a white male. So I would argue it definitely doesn't have to be race. But the one case I used, it was prior contacts with the district attorney, that it was punishment because of prior contacts. And
well, there's two cases from Wisconsin that they cite here. And my reading of those cases is that they both had a racial element to it. So maybe I'm just off base with my.
Well, most commonly it is. That was a very unusual case, and I really won't go unless y'all just really want me to. And I do feel when we talk about the issue of race, I think your listeners should know that in my mother's family, some of my mother's ancestors did own slaves. Basically, some of my mother's family came from South Central Louisiana. They did buy a big tract of land after the Louisiana Purchase, and some of them did have a handful of slaves. Now, the story that was told to me was that my mother's grandfather had a major problem with that, and that he very pointedly refused to accept his inheritance because of that. And that caused quite a bit of economic hardship in my grandfather's childhood growing up. But me personally, I feel like because my great grandfather refused to accept his inheritance, I do not feel like I benefited in any shape, form, or fashion from the fact that a handful of my ancestors did own slaves. But in the interest of full disclosure, the listeners, there's probably some people who will just ignore everything I have to say because of that. That's okay. Doesn't hurt my feelings. But I feel, for me personally, that my family debt has been paid off.
Yeah.
Well, let's talk about, I know on your notes there was this issue of what do they call that? Appropriation, not appropriations. There's restitution. Yeah. For slave owning. And Walter Block is someone I think who in the past has argued that there should be restitution paid because that goes along with libertarian principles. If there's an identifiable harm that can be traced back very directly, and I don't necessarily agree for punishing ancestors for the acts of their their precursors.
Well, I think at one point after the Civil War, there was a big thing of we're going to give slaves 40 acres and a mule. That was kind of like the big, we now call talking points in politics of give slaves 40 acres and a mule. And didn't work out very well because of Jim Crow. But at least back then I could see a point to it because you could clearly identify that that, this person was a slave. But we're talking over 100 years later. I don't see how you can directly point to saying that, my ancestors were slaves to the ancestors of Michael Ray Harris. So, I definitely don't feel like I should have to give them any money for that.
Right.
If they want to say that you should just print up money and give it to us, I think you're going to have a hard time showing the direct causation after all this time. Because we have so many people now that have voluntarily immigrated from Africa. I mean, Barack Obama is a textbook example. His father came from Kenya. I mean, his father, it wasn't a slave. His mother came from Hawaii. So she was a white woman. So kind of like why, and then he became a senator. He became a law school professor. He became a United States senator, and he became president. Why should he get restitution, for slavery? So I just don't. I just have a hard time seeing how you could prove it up now after all this time. Yeah. And by the way, most people don't know this, but in history, it was African tribes that started the slave trade. Mm-hmm. It was like one powerful African tribe would beat up a smaller, weaker African tribe, lock their men and women up in chains and sell them to the Europeans. So they're just as much a part of it as the Europeans. Are we going to go back to those African tribal leaders and make them pay? And then what do you do with people who are mixed race? I mean, it's kind of like, what part of them is the part that pays and what part of them is the one that receives? It's just, I just don't see how you'd be able to make it work.
Yeah. Well, and what about the Irish too? And I mean, there's lots to be said about the, there was an Arab slave trade too. That was, in my understanding, was a lot more brutal.
Actually, it still goes on. Well, I'm told that it still goes on in secret, but I'm told that in Arab nations to this day, there's still slave trade going on.
Yeah. Libya. I know there is in Libya, but that's our fault. So.
Yeah, they're going to find a way to blame everything on the white males. So,
well, I just mean it's directly the Obama State Department's fault with, Hillary Clinton in the Gaddafi intervention.
Yeah, overthrowing that regime and then just kind of like, all right, y'all go have fun. Yeah, and so now you have an open slave trade in the middle of Libya. So. Yeah. But
I don't want to mischaracterize Professor Block's arguments too, because knowing Professor Block, he's very careful and very nuanced. But I agree, how are you going to prove that? And then the whole concept just seems to be unworkable once you really think about it.
I liked Rothbard's assessment of it whenever he broke it down as a homesteading problem, right? So he was saying the plantation owners or the slave owners didn't actually own the property, that the slaves owned the property that they were working, because they are the ones who made changes to that property, right? And so if you could, and I don't know how difficult it would be, it seems like it would be damn near an impossible task to track down every person that is related to a slave, and then every person and then all those plantations and all that property, and how much of that property has been broke up and sold off and this, that, and the other. But that would be probably the best case scenario, is to give the people their property or to buy them off, if they didn't want the property. Some people don't want that responsibility of having that property. And we've seen this in other countries. And so it seems to me what they're trying to do is kind of the Zimbabwe model, where they kicked farmers off of their property because of their race and installed black, city folk to work it. And they're like, what the hell do we do with this? And we've seen it, because Beatrix is from South Africa. It happens in South Africa too. But they offered the people a buyout. Like, if you don't want to work this property, if you don't have the knowledge or capability to work this property, we'll buy you out, and we'll pay you for the land, and then we'll just let the land continue to go as is. So you might end up with a situation, if you go that route, to where you have modern property owners renting from, people that should have been property owners back in the 1800s, and it doesn't seem like a feasible route. I don't know how you would work all these issues out.
Statute of limitations.
Yeah, statute of limitations.
Is there a statute of limitations on slavery?
There should be.
Well, there's something called the 15th Amendment. Maybe you should read it, Tommy. But
I stop at 10 because I don't care about the rest of them.
Okay. Well, also another thing, that since we're going down this trail, what do you do with the Native Americans, as particularly the Cherokee and the Trail of Tears, who were very forcibly by the federal government kicked off their land at gunpoint? And
that was driven. My family was in there.
So to me, a lot of the Native American tribes, I don't think African Americans have a monopoly on mistreatment by the government. Okay. So right. I think you could definitely make an argument that a lot of the Native American tribes were treated as bad, if not worse. And also there's a long history of Asian Americans mistreated by the legal system. And the drug war in particular was very, very racist based. And when they came out with the original motivation for making marijuana illegal was the politicians in the states along the Mexican border wanted to basically try to keep Mexican workers from coming across and taking jobs from Anglos. And so basically they knew that the Mexican workers like to smoke marijuana, which is perfectly legal in Mexico. So they made it illegal for them to smoke marijuana so they could give them an excuse to arrest them. Okay. So, so that, and I don't know if you're familiar with the book Smoke and Mirrors by Dan Baum, where he interviewed somebody who worked for the Nixon administration, John Ehrlichman. And John Ehrlichman, point blank, said that, we created the war on drugs specifically because Nixon saw in 1968 he had two major groups that were opposed to him. That was the anti-war left and the blacks. And Nixon knew he couldn't run around arrest people because they were against the war, and he couldn't arrest people because they were black. But what he said he could do was he could associate the anti-war left with smoking marijuana, and he could associate blacks with using heroin. So, and he said, and they knew, he admitted years later that, it was race-based, and we knew it, that we were lying, and we knew it. We did it for purely political reasons.
Well, and the CIA are the ones who flooded the jazz communities with heroin back in the 40s. In order to sponsor their, pay for their, overseas ventures. You had Operation Sunrise and Operation Paperclip and all these things going on, and they had to pay for it. So what they started doing is they started working with the mob, and by working with the Italian mob, they started flooding the black communities with heroin by utilizing the Italian mob to sell to them. It's not much different than the Iran-Contra scandal when they were running cocaine into neighborhoods. It's the same IO. And if you can read about that in the book Operation Gladio, and there's all kinds of information about that and how the Vatican was involved in laundering money for all these people. Is just insane. And you're like, wait, so you create a problem, it's the what do they call it, the three steps? Problem,
reaction, solution.
Yes, the reaction part was the part I was having an issue with. I kept wanting to say something else, and I don't even know what it had to do with. But yeah, problem, reaction, solution. You create a problem, there's a reaction and you come up with a solution. It keeps you in power. It keeps you rich. It keeps money flowing your way. And, you know, it seems like that's been the way that the United States government has acted at least since the 40s, if not before that.
Well, I think definitely the behavior of the United States government after World War II is when we've started to become an empire instead of a republic. That you know, we like to think, we don't like to think of ourselves as an empire. Americans aren't comfortable with being an empire, but I think it's time to face the reality that, yeah, we got like 750 foreign military bases.
I had a guy tell me the other day, well, it wasn't the other day, it was probably about a year ago. He told me, he said, the U.S. isn't an empire because it doesn't have an emperor. Okay, I guess.
Well, I heard a discussion mainstream where one leftist blue tribe commentator say the reason why he hated Donald Trump was because Donald Trump was acting like turning the presidency into an emperor. And I remember a woman, she's kind of like, I got a news flash for you. That ship sailed long ago.
Yeah, right. Well, the emperor is not the presidency. The presidency, people have to understand, the president is a figurehead. If you can't look at Joe Biden and say, there's no way this motherfucker's running this country, like, then there's something wrong with you. Right? Because you could easily watch this stuff, and like we saw this with the Trump presidency. Patrick, you'll probably remember this better than I do, but there was I think he was a retired general who came out and said, "Oh yeah, we just told Trump we reduced the amount of troops in Syria. We've been increasing the amount of troops in Syria the whole time he's been in office."
Yeah. I remember that. I don't remember more of the details, but that certainly happened. Yeah.
It's just, these people aren't in charge. They're just figureheads. They're just there to look pretty, you know? And if Joe Biden is the prettiest we got, then we're in serious trouble. It's like Tales from the Crypt.
Well, I mean, they started losing me with the 2016 presidential election between Hillary Clinton and Donald Trump. And like right off the bat, like, huh? What's wrong with this picture? This is the best that the two-party system can give us. And then I looked at the pool for the Democrat side in 2020. I'm like, well, Tulsi Gabbard at least says some things I agree with. So I was hoping that she would come on. And basically, she got like 0.1% of the vote in Iowa, and I'm like, okay, so
yeah, there's a real sickness, and it really boils down to this whole culture war, and that's what I concern myself with when I look at the Supreme Court. I'm not so much concerned with the justices that they put in there. I'm more concerned with how they're choosing these justices and what is expected of these justices, right? I see the right, they kind of rally around Clarence Thomas, and you know, I'm waiting for the left to get their justice, that one that's always spewing their talking points, and it is involved in that leftist culture in such a way that they're an activist. I don't worry so much about activism from the conservative movement because they're not good at activism. They're really bad at it, you know, and so, but the left has perfected activism, and they know how to make it sound official, like, if that makes sense. And so it's creating like the pendulum swing but instead of the pendulum coming to a rest in the middle, that pendulum is just swinging harder and harder and harder each way. And the more it swings each way, if the Supreme Court follows suit and goes in that direction to where they're split and divided in that way, you start seeing the battles within the court between quote unquote conservative justices and quote unquote progressive justices, then it's going to spill out into the culture and it's going to create more of a divide. We're already hitting a point to where like political violence is considered okay. And it worries me for like my kids who live in a city. Like I don't live in a city. I'm like, whatever. Like most of this shit ain't going to touch me. But for my kids that do live in a city, then I have to think about like, how is this going to affect them? Are these cities, are we going to start seeing this divisive rhetoric that we hear turn into divisive behavior? And when it turns into divisive behavior, how far is it going to go?
Well, I can tell you that I practice law in both a rural county and an urban county, Dallas and Kaufman. And it is like night and day difference. And this past 2 years, I've made the decision that I'm going to finish out my Dallas. I stopped doing cases in Dallas. I'm just going to finish out my current one with this COVID craziness that hit. I've told people at the Dallas County Courthouse now that I feel like a saltwater fish in a freshwater pond. It's just I just don't belong there anymore.
Right. And
I've got very real concerns. Well, I live to see the breakup of the United States. Will it become like city states? Will Dallas and Fort Worth become like their own little independent city states? And I haven't been to California in several years, but from what I've heard, they're going off in la land as far as their legal system. And especially, and I think the COVID pandemic really exposed a lot of it. And I don't know if we can come back from it, really, to be honest with you.
I'm really
the Supreme Court's becoming more and more partisan as well. What do you think, Patrick?
I see Patrick down there working his ass off. He's researching and looking things up as we're talking.
No, I was just trying to remember that Sotomayor was the justice who just seems to be completely off in her own reality. Especially with the oral arguments over the OSHA case.
Oh, geez, I almost forgot about that. Yeah. Michael and I did talk about that a while back.
Yeah,
that was insanity.
But I mean, I'm seeing it here, and you're right. It really is an urban-rural divide because. So the other week, in my state, the state public defender's office, we had in Wisconsin, we had a constitutional crisis a few years ago because the state public defender's office can't handle the volume of clients that's coming their way. And what they've been doing, and I'm sure they do this in other places, is they contract defense work out to members of the state bar. So you have the staff public defenders, but you also have private attorneys who take public defender cases. So I've been taking some public defender cases, and a few years ago we had a constitutional crisis because the Wisconsin Supreme Court, and I think they needed the legislature to do this, but the private public defender bar rate was at $40 an hour since the 70s. And it was that low until maybe 2018 when they raised it to $70 an hour. And especially underserved are the rural counties where some people would be waiting months for attorneys. And now during COVID-19, you had people waiting in jail for a really long time because we suspended all jury trials. So the public defender's office has been saying, oh, well, we are in such desperate need of rural attorneys to take public defender cases. We're having public defenders from the south of the state around Milwaukee and Madison represent clients in rural northern Wisconsin. And they've been doing almost all their hearings by Zoom. So you would think that a young private bar attorney who's willing to take public defender cases would be really, really valuable to the state public defender's office, right? Because all of our rural attorneys are in their 50s and 60s. So they have this free training through a federal program to train members of the private bar to take juvenile public defender cases. And they had a free training in Wausau, which is a city that's about an hour from where I practice. So I show up, and of course they mail out ahead of time that, oh, well, we're going to abide by social distancing and everyone needs to wear a mask to this thing. And so I just didn't really think much of it, but I'm fucking done with the mask thing. I've been done for like over a year. So I show up and I thought about it for a second, and I went up to the door and I was like, I'm just not doing this today. So I go in and I'm the only person not wearing a mask. And I'm sitting there and we get through about 45 minutes of the whole thing. And one of the staff members comes up to me and is like, excuse me, sir, can you put a mask on? And I was like, well, are you going to kick me out if I don't? And she said, yes. And I stood up and I was like, all right, I'm fucking out of here. Like, I guess you don't care about having competent representation in rural areas like you say you do. And so I left. But the cultural, I guess that's just emblematic of the cultural disconnect between the rural areas and because all these people are from the staff office in Madison. So it's in my mom is a judge too, and she's on the criminal bench book committee. And so all these judges from around the state meet, and she's been insisting on doing Zoom meetings for these bench book committees, because otherwise she would have to go to the office of the state bar, which requires vaccination upon entry. So to kind of put a bookend on this, Michael, what's going to happen is that if you're unvaccinated, you're not going to be able to have your bar license anymore. And I'm waiting for this to come. And I hope it never comes. I hope I'm wrong. But things are going to diverge so much in these institutions like the state bar are becoming so progressive that they are going to condition your license on their agenda of social justice and their agenda of, COVID-19 vaccines and things like that.
I think that is coming in some states. I don't think that's going to come in Texas. I mean, as much as Tommy knows that I have trashed Texas Attorney General Ken Paxton, that much. I mean, I believe in giving the devil his due when he's right. He's a crook. He belongs in jail. He definitely does not deserve to be Attorney General of Texas, but he is, and he does it for political performance art. He knows that a large percentage of his voting base is opposed to the vaccine mandates. So in Texas, I think we're safe from the vaccine mandates.
I do worry about it as far as trucking goes, because we're regulated federally.
Yeah.
And so I have to get every 2 years. A lot of people don't know this about truck driving, but every 2 years I have to renew a medical card. So I have to go get a physical done and all this stuff and I have to have a medical card in order to renew my CDL. So I'm up for a medical card this May. All right. I was pretty certain that they were going to put a mandate for vaccines in order to renew your medical card by the time I was going to get mine renewed this year. I'm not as certain now. It's starting to look like people are starting to backtrack on it because it's not popular. And if there's anything a politician doesn't like, it's being unpopular, which, I mean, they have a lot of ground to make up there. But so I don't think they're.
I think it's like former New Jersey Governor Chris Christie's like the science changed. The political science was what.
Yeah, exactly. Yeah. Yeah, I don't necessarily think they're moving in that direction. What I would suggest that y'all look into, if you're really concerned about the way that they're going to be monitoring the way people interact and things, is it's something I've hammered on, and I'm sure y'all both heard me talk about it, but ESG and the ESG scores, they'll be able to utilize. So they're like, we all know that they debanked, and there were certain card support that canceled Alex Jones. We saw the same thing with Donald Trump when Donald Trump left the White House, that there were banks that refused to do business with him anymore. So, and then we saw the freezing of bank accounts up in Canada. with the trucker protest. So what they're doing is they're giving you it's a social credit score, but they're doing it instead of through the government, they're doing it through the banking institutions. So if you have a 401k, you could probably go to your 401k, especially if you're with a big company like Merrill Lynch. You can go to your 401k dashboard and it'll have a score up top. It'll say ESG score. It'll have a score for you. It'll tell you what your ESG score is. If your ESG score falls below a certain percentage, then you're not eligible for certain loans. You're not eligible for certain activities. You're not eligible for certain banking options. You're not eligible to, to even access your accounts and access your own finances. Right. And this is all something they're moving towards, and they admittedly are moving towards this. I've read it several times. It was a statement by the SEC when they created an ESG task force for investors under $250,000. Right. So, you're talking about people like buying Bitcoin. You're talking about people. What they're doing is they're tracking your banking. We saw them do this on January 6th. Where Bank of America started turning over records of everybody that had bought anything, any of their customers that had bought anything in Washington, D.C., that in the days surrounding January 6th. And they turned over all these financial statements to the FBI so that the FBI can investigate these people. So they're utilizing private corporations to work alongside the federal government in order to backdoor the Constitution. So your concerns about not being able to get a law license are very well warranted, but it's not going to be for the reasons you think it is. Because the vaccine mandates, health and safety fell under the S in ESG. It's environmental, social justice, and corporate governance. The social justice aspect has a separate, like a tree. There's a tree that comes down of all these different bullet points that fall under social justice. Health and safety is one of those bullet points. So you're well warranted in worrying about the possibility of not being able to renew your law license because of the standards, but it's not the vaccine mandate that is the ultimate standard. It's this environmental, social justice, and corporate governance score that you really have to keep an eye on.
Well, realistically speaking, like I'm not in morbid fear of this, because in all actuality, if they had to institute something like that, there would be no lawyers in large areas of Wisconsin. That's just the way it would be. There's a constitutional crisis now, but if they cut out even 1/5 or 2/5 of the lawyers in Wisconsin, it'd be really bad. So what do you think about that, Michael?
Well, I can tell you that we did have this come up in Dallas, where they were going to try to say that, you had to show the vaccine in order to get court appointments in Dallas. And there was, in particular, some African-American lawyers. It's kind of like, excuse us, but this sure looks an awful like the Tuskegee syphilis experiment.
Well, good for them.
And it violates the HIPAA laws, and we're just flat not going to do it. And so, there was a faction of lawyers who just flat rose up and says, we are not going to accept court appointments. And I can tell you that I saw the handwriting on the wall. I'm 57 years old, and I own a house in the country. My student loans are paid for. I inherited a chunk of money when my mother died. So it's like, you know what? I'm ready to go back to the country anyway. Yeah. So I just got off the appointment list in Dallas. It just kind of like, but it was, I think I was heading in that direction anyway, but it was kind of like, that was kind of like the final thing that pushed me to like, you know what? I'm ready to leave Dallas.
Yeah. Well, there was the young lawyers branch of the state bar. And I think as things were kind of opening up, they sent out a Google survey asking, like, if we were to move back in person for our convention, what kind of like COVID like restrictions or precautions, they said, should we put in play? And one of them was requiring proof of vaccination. And I wrote them a very, very strongly worded response to that. And so they just probably wrote me off that I'm some kind of kook or something, because I know how that goes.
Well, and I've been quite amazed by how many even criminal defense lawyers who are part of the COVID cult.
Yeah.
And I've had some discussions with them that's kind of like, I was trained that my number one job as a criminal defense lawyer was to point out the weaknesses in the government's case.
Yeah, right.
And here y'all just blindly accept everything that this unelected bureaucrat who's never treated a patient his entire life successfully tells you is quote unquote the science.
Yeah.
And you just accept it like it's handed down by Moses from Mount Sinai. It's kind of like, what's wrong with this picture? And I told one of them point blank, it's like, you know what? I'm glad you're not my attorney. All right.
I got real mad, and like I didn't make a scene or anything because I'm at the point where I need public defender appointments at this point in time. It's growing that I don't, but at the same time, I wanted to like make a big deal out of it and say, like, you guys are supposed to be the ones fighting the system, right? You're the rebels. You're the public defenders that are going to get in and fight on behalf of the underrepresented. But no, you're just a part of the fucking system. Like, I hate that.
I mean, that's always been kind of my thought. It always seems like, because it seems like the public defenders are the ones who push the settlements and not going to jury trial.
I think it is like, I don't want to throw them right under the bus, because there are some public defenders out there who are better than the private bar. I mean, this is all they do, and they fight valiantly for their clients. Right. So I guess I'm not going to put everyone in one category, but there is an argument to be made that they just enable the system by being part of it.
Right. And I think that was just always my opinion. Like, I had nothing to back it up. But when you see so many like trials canceled because of plea agreements, then you got to wonder, like, who are the attorneys that are making these agreements and talking you're talking to somebody that doesn't know the law and that doesn't understand how it works. And so if you come to them and you say, okay, they're offering to give you deferred adjudication, let's say. And by giving you the deferred adjudication, if you complete your probation over the next 2 years, then this will be completely wiped off your record. You can do that, or you can go to a jury trial. More than likely, you're going to be found guilty in a jury trial, and that person accepts the plea agreement. Well, you don't know. Like, you don't know that you would have been found guilty. You could have gotten a jury like Michael had the other day, where he got somebody off of a small drug charge. You don't know. And so it's so ingrained in our heads that we follow the specialist, right? And this goes back to the COVID cult and the administrative state. We're supposed to follow the specialist. And we look at the Supreme Court, and the Supreme Court saying, well, yeah, the specialists, the administrators, are the ones who are making these decisions, and that's what you're supposed to listen to. So it's just pounded in our head, this, authority is, you're supposed to be subservient to any authority. And, well, maybe that's not best for me. Maybe being subservient isn't the best move for me. But who's there telling these people that?
Well, I stopped counting after 20 how many jury trials I did. Okay, I mean,
that's because you're a rebel. You're a real rebel, Michael.
I was in my younger days. Okay, I mean, and also I had the advantage that the district attorney in Kaufman County from 2003 to 2007 was an absolute idiot, and so basically, I would tell a lot of times the clients, like, you know what, you got nothing to lose by going to a jury trial, because this district attorney is such a, crazed drug warrior type. So, yeah, I mean, in 4 years, I did 14 felony jury trials in 4 years. Patrick, I'm guessing you probably hadn't done 14 felony jury trials your entire career. So yeah, I had a lot of trial experience because I was just simply one of the few people that was willing to stand up to this out of control district attorney in this rural county in Texas. But the flip side is the one case that will haunt me to the day I die was a murder case where I absolutely positively believe my guy acted in self-defense. Every cell in my body believed he acted in self-defense. I encouraged him to go to a jury trial. I believed in him so much. I had 2 of the state's own witnesses in the jury trial testify in trial that they believed my guy acted in self-defense. Yet the jury found him guilty of murder. And I had to watch that young man go to the penitentiary for 40 years. And I learned a very painful lesson that day. And I went and told him afterwards, kind of like, you know what? I sent a letter to the parole board telling them that I believed in him and I encouraged him to go to trial, and I still believed he acted in self-defense. But you know what? And I tell people this day, no matter how much I believe in you and I believe in your case, when that trial is over with, Michael's going to walk out of this courthouse, okay? I mean, I can't guarantee you that if you go to a jury trial that you're going to walk out of the courthouse.
Right.
I mean, if they offer you a plea deal where you got a guarantee, in the federal system, we refer to this as limiting your exposure, which, Patrick, I don't know if you've ever done a federal criminal case before.
No.
I don't encourage it. I think every lawyer should have to do one federal drug conspiracy trial, and no lawyer should have to do 2. Because, you want to talk about a rigged system. Yeah. That, my friend, is a rigged system. The federal drug conspiracy trials. Yeah, I could do an entire podcast on that subject alone.
Yeah. Well, I got 4 years of experience in September or October. Will be my 4 years of being admitted. I got the 2 bench trials, but I don't have any jury trials yet. But I got one coming up in April, my first one. So that one's going to go. That guy allegedly is on video stealing money from a bar. But yeah, it's really kind of stacked against the defense. And I've been leaving the decision. Of course, you're supposed to leave the decision up to the client about what they want to do. But I've heard clients tell me that they've had public defenders that told them to take the deal.
Oh yeah.
Forcefully.
I have witnessed in particular times when people were prosecutors and they either left or got fired from the district attorney's office and went to do court appointed work, and they still walked in that jail with a prosecutor mentality. And in one case in particular, I pulled a woman like that off to the side after hearing her talk to her client. And I told her point blank, like, you better hope that guy does not file a grievance with you or gets the state bar and call me as a witness. Okay.
Yeah.
Yeah. Like, if you're going to be on this side of the fence, you better change your attitude real fast.
Yeah. And
I'm not going to warn you again.
I'm not saying it's wrong for defenders to tell their client to take the deal, but always with the caveat that, hey, it's your right to go to trial and we can go to trial. I just think the best likelihood for the best result for you is to take the deal.
Well, a lot depends on if they're in jail or on bond. Because if they're in jail, time is on the prosecutor's side. If they're on bond, time's on the defendant's side. Yeah. And especially with the COVID crazy world we lived in the last 2 years.
Yeah.
I mean, we had no jury trials for 2 years in Dallas County. And people that were stuck in jail, not able to go to jury trial, it really, to me, was disgraceful. And kind of like the one that I had that finally went to the jury trial in January. I mean, it was a very low-level drug case, so the maximum punishment was 2 years in penitentiary. she'd been in jail 20 months waiting to go to jury trial. So I'm
Yeah.
like, hey, even if you
Time
go to
served.
trial and lose,
Yeah.
you're looking at another 4 months. So what? You
Yeah.
know?
See, my guy, sorry, Tommy, just to tell war stories here.
No, go ahead. I'm enjoying this.
That's what we lawyers do. We tell war stories.
My guy is currently in jail right now. And when he, according to what the deal the state has offered, he could do time served right now. But the problem is that he's going to go right to prison in Michigan. And so at this point in time, we're just going to invoke his right to a jury trial. And if we win, then he wins. And if he loses, then we win. So it's the perfect
out-of-state hold. He's got the out-of-state hold. So yeah, he's not getting out anyway.
It's the perfect environment for me to do my first jury trial.
That's exciting shit, though. I'm sitting here like trying to imagine you giving like a closing statement, getting all passionate, because you're so level-headed. Like you always know all the facts. Like
I appreciate it.
I'm just like,
Unless you're talking to Michael.
No, I'm talking to you. I'm trying to imagine. I'm trying to how does Patrick, pull out a Mississippi Burning type of like closing statement?
When none of the facts are on your side, you can always rely on the due process argument.
And don't forget, you can always argue Marbury versus Madison that the statute's unconstitutional.
Right? Yeah. Or there's a jury nullification instruction here, but you can't make the court give it.
Well, here's a question I would have about going to trial. And this, if let's say you take on a case and you believe your defendant is innocent, and you get 3/4 of the way through the trial, and then you realize, oh shit, no, this guy's guilty. Like, what do you do?
Don't care.
Are you supposed to keep defending him, or are you supposed to just be like,
yeah,
you have to.
Yeah.
Even if you know that it's not right to do?
Well, basically, I know this is going to stun you, Tommy, but clients lie to their attorneys. Sorry.
Oh, yeah.
That's the reality. Yeah, and I've been in the middle of jury trials when it was very blatantly obvious that my client had lied to me. And I remember one time in my closing argument, I stood in front of the jury and I says, you know what, folks? 20 years I've been saying that you give the defendant the benefit of a reasonable doubt, and I'm not going to stop saying that now. So I went on about a 10-minute sermon about about what reasonable doubt means, and that's all I talked about.
Yeah.
And that was all I could say. And
there are a few things where you're allowed to withdraw according to the ethics rules. One of them is like a fundamental breakdown in communication. The other is like if you have a fundamental disagreement with the course of action. But I think that is in like an ethical sense. Like if your client, I don't know, if you discover that like in the course of your representation, you can't commit a criminal act on behalf of your client. But there, at least in the Wisconsin ethics rules, it says if you have a fundamental disagreement with your client, but that doesn't mean my client won't take the plea deal. So we have a fundamental disagreement and I'm going to withdraw,
Right. But like during closing statements, you can't get up there and be like, all right.
You can't leave him in a position that's fundamentally exposed. You can't leave him hanging in a sense. Like the court has to approve of your withdrawal.
See, well, no, I'm not even saying withdrawal. I'm just saying like you couldn't get up like in a closing argument and just be like, okay,
ineffective assistance.
Men and women of the jury, I've been seeing the same evidence that y'all been seeing, and he's guilty of sin. Have fun.
Nope.
And just walk away. I mean,
better call your malpractice insurer.
Yeah, that's
on your way out the door.
Yeah, I mean, I don't know how it's malpractice telling the truth though. It's like it just seems like okay, like I have my own morals and ethics, and to the dude did it. Like, he murdered that kitten. I saw him.
Yeah.
Well, I can tell you, I'm going to tell a war story now. The case was statutory rape. Basically, I was appointed to represent a guy that he got he was from Puerto Rico, and he got a 14-year-old girl pregnant.
Mm.
DNA proved it. He was the biological father. Okay, so there's no way to get around it. Basically, I told the guy, look, and he kept saying, hey, I'm from Puerto Rico. This is part of our culture. Like, yeah, I'm from Southeast Texas. That used to be part of our culture 50 years ago too. But kind of that ain't going to fly in Dallas County, Texas, in 2000, and this was February 2020. Yeah. And I told the guys kind of like, the only defense that I can see is kind of like, if you were drunk or you were sleeping and she enticed you while you were drunk or sleeping. Yeah, that's what happened. Like, okay, I can make that argument. Okay.
Sure.
That's and then at the end of the jury trial, my genius client is kind of like, oh no, I wasn't drunk. I knew exactly what I was doing. I'm like, thanks a lot.
Yeah, you just hang me out to dry. Yeah.
Yeah,
Well,
it's kind of like, it's like during the cross-examination, it's like, you did tell me that you were sleeping when that happened. Isn't that what you told me, sir? Like, yeah, that's what I told you. Like, okay. I'm like, folks, I don't know what to tell you.
Well, moreover, Tommy, like, I guess even if you're defending someone who's a horrible, atrocious murderer, then you really think about, do you believe in due process or don't you? Then you really, in your mind, I mean, it's like, I am putting this trial on not for my client who's guilty and is obviously going to be proven guilty. I am putting this trial on for you, the jury, and for everyone else in this courtroom who is sitting here. You can't, I think that violates the golden rule. You can't argue that to the jury. But you're saying basically, I'm doing this trial for due process, because any day now, any time, one of you could be accused of a crime that you did not commit.
Right.
And by putting this person through the process, we are solidifying the rule of law, which I know is a myth, but we're solidifying the fact that in a civilized society, we have a process we go through in order to convict someone.
Right.
That's why we're doing this.
I agree with that breakdown. I just think it would be really difficult to try to defend somebody after I know that they're guilty. Like, I just know my personality. It might just be a personality thing too. Like,
well, it's something, Tommy, that you learn to do it. If you can't do it, you wash out at the misdemeanor level. Okay.
Yeah.
I mean, now, like I said, I go back to my experience because, like I said, there was a period of 4 years in Kaufman County where I was one of the few attorneys who was even willing to take court appointments. So, yeah, I saw firsthand what it was like when there was nobody to provide, effective counsel. I mean, people think I'm joking when I say this. Actually, I literally met people who had been in jail 2 years with no formal charge against them. I saw that firsthand in Kaufman County. Yeah. And I told the judges, like, try to imagine some Arab country holding American citizens in prison for 2 years with no formal charge against them. What do you think we would do?
Yeah.
Like, we'd send in divisions of Marines. Okay.
Yeah, right.
Like, we can't have this.
Yeah.
And so, yeah, I saw firsthand what it was like when there was no, like, basically it was just me and a couple other people that were willing to step up and do it. So, yeah, I earned my stripes, but and yeah, I've had some tough cases. I'm not going to lie about it. But ironically, the worst one I ever had was when it was a parole violation. It wasn't even a jury trial, but, which I won't go into that one unless y'all really want me to. But you just learn that it's part of the job, and if you can't handle it, you wash out at the misdemeanor level. Yeah, sorry, but that's just the nature of the beast.
Yeah.
Well, and your clients deserve a trial too. I mean, they deserve to have adjudication and the final result, even in appeals notwithstanding.
Well, the way I see it, you either believe someone has a right to a jury trial or you don't. You believe they have a right to competent legal counsel or they don't. And if you can't do you can't do the job, you shouldn't do court appointments. That's my feeling about it.
My battery ran out.
Oh, is that what happened? And I was like, oh, we have no video for Patrick. Did he disappear on us?
Yeah, sorry about that.
No,
hey,
that's
I got to
okay.
get running anyways.
Yeah, that's fine. Michael, you had said something about one case that you thought was important to mention here, and you wanted to expand on it. Do you have a few minutes for that, Patrick?
Yeah.
Well, I think that the Korematsu case.
Yes.
Yeah, that's a very famous case during World War II, where the United States government literally locked up people because they were the Japanese ancestry, not because they committed any crimes or done anything bad, just the mere fact that they were of Japanese ancestry. And if you ever get a chance in New Orleans, they have a World War II museum that you really ought to go to. And they have part of the museum is dedicated to the story of these Japanese Americans, these American citizens of Japanese descent who were locked up in these internment camps. And the part that really struck to me was they interviewed this guy. He said he was a 5-year-old kid at the time, and they took him to this camp. And they told him, don't worry about these machine guns because these machine guns are here for your protection. And he said, I was a 5-year-old kid. And it's like, if they're here for our protection, why are the guns pointed into the camp? I mean, as like 5-year-old kid, I could see through that lie.
Yeah.
But the United States Supreme Court upheld is a very famous case called Korematsu, where they upheld the constitutionality of locking up people for no other reason than the fact that their ancestors were Japanese. And that stayed on the books until very, very recently. And finally, Supreme Court Justice Roberts finally, after a couple of years ago, finally said, you know what? We were just wrong with Korematsu. There's no other way to say it. We were just wrong. And so they did formally overturn the Korematsu case. But I point that up because of all the critical race theory people. Like I says, the African Americans, they don't have a monopoly on mistreatment by the government. Now, I think I am kind of concerned now because I think there's a movement to create statutes saying you can't teach critical race theory. Well, I don't see how you could draft a statute that's a legitimate part of our history. And I think it should be told as a legitimate part of our history. So was it racist? Yeah, it was racist. I'm sorry. But it's a part of our history and it should be taught. And we should learn from that. I heard, I'm a history major. And one of the things they told us is that people who don't study history are, condemned to repeat it. People who do study history are condemned to sit and watch others repeat it. So, we should learn from our mistakes of the past. So we should study cases like Dred Scott. We should study cases like Plessy versus Ferguson. We should study cases like Korematsu, even though they were inherently racist in their day. We should study them and we should learn from them and hopefully avoid the same mistakes.
I think the problem that a lot of people have with the critical race theory style entering into the schools is because it is at its essence racist, because it demonizes, like you said earlier, like all white people are evil now, and so it puts that at the front. Like if this were just let's teach the horrible atrocities of the United States, I don't think near as many people would have as much problem with it. But when you're telling a 6 or 7 year old kid that they are inherently evil because of their color of their skin, I think that's what people are having a problem with.
I mean, I haven't witnessed it firsthand, but I've heard stories from parents. They've and I think a lot of it stems from the teachers union, and they have a political agenda, and I think its roots are actually from Marxist roots. And
that's what James Lindsay says. And,
and I think
he
so.
makes a compelling argument for it.
But so, like I said, I think these people they're not there to educate; they're there to indoctrinate. And I think in the pandemic, when a lot of parents were at home and the schools went to virtual learning, and they saw it firsthand, and they were just repulsed by it. And I think with good reason, from what I've heard.
All right, Patrick, what's your take on this whole situation? Do you think it is? I think it was it DeSantis came up with the idea like, oh, we can't effectively ban critical race theory. Or no, this was in Texas. We can't effectively ban critical race theory. So what we're doing is we're opening up the courts for parents to be able to sue these school districts that are actually proponents of critical race theory. So
for an intentional infliction of emotional distress.
Yes. Yeah.
Actually, it's the civil rights. My understanding is that they're making the arguments under the Civil Rights Act of 1964 that it's and I'm not an expert on Civil Rights Act 1964, so I don't know what the exact nature of the argument they're making, but my understanding is that that's the basis of the legal arguments they're making.
I was being tongue-in-cheek a little bit with the severe emotional distress. No, but I think it's interesting, and I struggle with it because I have a piece coming out criticizing DeSantis, so I think that's going to cause some waves in the libertarian sphere when that comes out.
No.
I'm sure everyone will love it, but I struggle with it because in a way I think I do support that legislation he wants to put forward, because if you're going to indoctrinate kids, or if you're going to force children to go to public schools, then you better not be indoctrinating them with state propaganda while they're there. I mean, I don't know how to get around that.
As John Taylor Gatto pointed out, what else are they going to indoctrinate them with?
Right.
Actually, I kind of want them to keep amping up the critical race theory in public schools so that more people pull their kids out of these schools and homeschool them.
Yeah.
I mean, honestly, it's like a pressure point. Eventually these parents are going to be like, I'm so sick of this. There's nothing I can do about it other than homeschool my kids. Right. And that's kind of like the way I look at it. Like it's almost like a necessity to show that the things that the schools have been focused on for all these years have not been beneficial to children.
Right.
So, all right. I know you got to go, Patrick. As much as I'd like to keep you here all night long, you do have a life. So, plug away, Bubba.
Yeah. So I host Liberty Weekly podcast at libertyweekly.net. I'm a writer and researcher and practicing attorney. Liberty Weekly podcast is also featured on the Libertarian Institute at libertarianinstitute.org. And I'm doing all my stuff through Substack now, like early previews of the articles that I'm going to be writing for the Institute. Nice. And bonus content for my podcast. So libertyweekly.net/Substack.
Okay.
Thanks.
Yeah. And Michael, you got anything you want to plug? Are you writing that book yet?
No, I'm too old and army so I'm definitely not running for public office anymore. I'll guarantee you that. So,
well, as Bernie Sanders says, if you write a book, you can become a millionaire.
Okay.
Well, all right. Well, this was a great conversation. I really enjoyed it. I kind of got some insight just from y'all's points of view, because y'all are talking about all kinds of things I hadn't even thought of. So this was fun for me.
Yeah, it was great to meet you, Michael. And I hope you don't mind if I email you with if I have things that come up in my cases and I need your advice.
Okay. Yeah, no problem. I'm glad to help when I can.
Yeah, I appreciate it. It was nice to meet you.
Nice to meet you too.
All right. Well, that was it, man. I'm going to call it quits right now.
You wanna be a hero, instead you're just a slave. intentions took you to your grave. Your pride is how they killed you. With the flag you wave just like a fool. They promised you a mountain, gifted you a stone. They demanded that you throw it into your neighbor's home, and then seize all that they worked for and give it to the throne just like a tool. Well, as we all just stand in line and glorify new ways of being cruel, it seems to me humanity is not something that they're teaching us in school. They dumb us down all around, propaganda, their pollution. They set a cage up on the stage, a facade for all solution. They build a wall, block them all from this mental institution. It's insane. Now they're writing their own rule books and they're crossing all their T's. They're fashioning their people to all wear beggars' knees. If you want a clean drink of water, well, you must say pretty please. It's all a game. Well, as we all just stand in line and justify these crimes done in our names, it seems to me authority and tyranny are both one and the same. Well, it's time to change the channel. It's time to set things right. Make them all rot with fear in their beds at night. Devour all their worthless souls and sacrificial right, just like we should. Of those who are to blame, and we'll stack them up like cordwood, watch them sizzle on the flames for good. Well, as we all just stand in line waiting for some kind of Robin Hood, our liberty will never be until our right to freedom is understood.